Lesson 15. Intellectual Property Rights for CS Exam. Intellectual Property Rights. Introduction. 1. Intellectual property rights (IPR) are legal rights given to creators for their creations. 2. Protect creations of mind right pointing arrow inventions, artistic works, symbols, names, designs, trade secrets. 3. Encourage innovation, creativity and fair competition. 4. Rights include exclusive rights, including selling, licensing, transferring rights. 5. IP laws aim to prevent unauthorized use of intellectual creations. 6. 2 broad categories: industrial property and copyright. 7. IP protection fosters economic development, technology transfer and R&D. 8. Governed by domestic laws and international treaties. Case law, Eastern Book Company vs. D.B. Mode Act 2008. SC held that creativity, not mere labor, gives copyright validity modicum of creativity test. Regulatory framework. 1. Indian Constitution. Art. 246 in Union List. Parliament has power to legislate IP laws. 2. Indian Patent Act, 1970. 3. Trademarks Act, 1999. 4. Copyright Act, 1957. 5. Designs Act, 2000. 6. Geographical Indications of Goods Act, 1999. 7. Biological Diversity Act, 2002. 8. Cinematograph Act, 1952. Film piracy. 9. Enforcement through IPAB now under High Court jurisdiction after abolition in 2021. 10. India is a signatory to WTO TRIPS, WIPO, Paris Convention, Berne Convention. Nature of intellectual property. 1. Intangible asset, cannot touch but has commercial value. 2. Exclusive right to creator. 3. Territorial right. Protection limited to jurisdiction unless international filing. 4. Time-bound protection e.g. patents 20 years, copyright lifetime plus 60 years. 5. Transferable and licensable like physical property. 6. Encourages R&D, innovation, branding. 7. Can be enforced legally right pointing arrow injunctions, damages, penalties. 8. Monopoly right granted for limited time to encourage public disclosure. Need for intellectual property. 1. Protects creators' rights. 2. Encourages innovation and investment in R&D. 3. Prevents counterfeiting and piracy. 4. Promotes economic growth. 5. Ensures fair competition. 6. Helps in brand building and goodwill. 7. Attracts foreign investment and technology transfer. 8. Supports creative and knowledge economy. Scope of intellectual property. 1. Patents. 2. Trademarks. 3. Copyright. 4. Industrial designs. 5. Geographical indications. 6. Trade secrets. 7. Plant varieties and farmers' rights. 8. Semiconductor layout designs. 9. Biotechnology IP. 10. Software and computer programs. The General Agreement on Trade and Services GATS. 1. Component of WTO agreements covering global trade and services. 2. IP-related services. Software, licensing, patents, franchise, technology consulting. 3. Ensures equal treatment MFN to foreign service providers. 4. Covers market access commitments for IP services. 5. Facilitates technology and knowledge services trade. World Intellectual Property Organization WIPO. 1. UN Specialized Agency for IP Protection Est. 1967. 2. HQ. Geneva, Switzerland. 3. Administers 26 plus treaties Paris, Berne, PCT, Madrid, Hague. 4. Provides international filing systems e.g. Patent Cooperation Treaty. 5. Promotes global IP harmonization. 6. Offers dispute resolution, research, databases WIPO Lex, PATENTSCOPE. 7. India is a member since 1975. Trade-related aspects of intellectual property rights TRIPS. 1. Core IP agreement under WTO 1995. 2. Minimum standards for IP protection globally. 3. Covers patents, copyright, trademarks, GIs, trade secrets, designs. 4. Non-discrimination and national treatment principles. 5. Compulsory licensing allowed for public health. 6. Implemented in India through Amendments Patents Act 2005. 7. Ensures enforcement mechanisms and border control for fake goods. Case law, Novartis AGV, Union of India 2013. SC refused patent for Glivec. Must show enhanced efficacy for pharma patents Section 3D to prevent evergreening. Concept of intellectual property. 1. Rights from creative and inventive activity. 2. Encourages public disclosure in exchange for protection. 3. Monetizable legal asset. 4. Grant based on originality, inventiveness, distinctiveness. 5. Prevents unauthorized use and exploitation. 6. Forms basis of knowledge-based economy. Industrial property. Includes 1. Patents. 2. Trademarks. 3. Industrial designs. 4. Geographical indications. 5. Trade secrets. Patent. 1. Governed by Patents Act, 1970 amended 2005. 2. Protection for new inventions. 3. Duration 20 years from filing date. 4. Rights. Exclusive use, sell, license, assign. 5. Criteria. Novelty, inventive step, industrial applicability. 6. Non-patentable. Abstract ideas, laws of nature, plants, animals, mathematical methods, business methods, surgical methods Sec 3 and 4. 7. Compulsory license available after 3 years for public need. 8. Patent infringement right pointing arrow injunction plus damages. Penalty. False representation of patent. 1 lakh rupees to 10 lakh rupees fine. Case laws. Baer vs. NATCO 2012. First compulsory license in India. Diamond vs. Chakrabarty US. Genetically modified organism patent upheld. Trademark. 1. Governed by Trademarks Act, 1999. 2. Protects brand names, logos, slogans, shapes, sound marks. 3. Duration. 10 years renewable indefinitely. 4. Distinctiveness required. 5. Infringement right pointing arrow civil and criminal actions. 6. Passing off for unregistered marks. 7. Certification marks and collective marks available. Penalty. False trademark use. Up to 3 years imprisonment plus fine up to 2 lakh rupees. Case law, Cadilla Healthcare Limited vs. Cadilla Pharmaceuticals 2001. SC laid test for passing off and consumer confusion medical products. Copyright. 1. Copyright Act, 1957. 2. Protects literary, artistic, musical, dramatic works, software, films, sound recordings. 3. Duration. Lifetime plus 60 years. 4. Does not protect ideas, only expression. 5. Infringement right pointing arrow injunction, damages, seizure of copies. Penalty. Min imprisonment 6 months. 3 years, fine 50,000 rupees. 2 lakh rupees. Case law, RG. Anand vs. Deluxe Films 1978. Idea not copyrightable, only expression. Industrial Designs. 1. Designs Act, 2000. 2. Visual features. Shape, pattern, ornamentation. 3. Must be new and original. 4. Duration. 10 years plus 5-year extension max 15 years. 5. Purpose. Aesthetic appeal in industry. 6. Infringement right pointing arrow civil remedies. Geographical indication GI1. GI Act, 1999. 2. Identifies goods having geographical origin and qualities. 3. Duration. 10 years, renewable. 4. Examples. Darjeeling tea, Kanchipuram silk, Palakkad Mata rice. 5. Collective right. No individual monopoly. Trade secret. 1. Confidential business information protected without registration. 2. Examples. Coca-Cola formula, Google search algorithm. 3. Protected by contracts, NDAs, common law. 4. No statutory definition in India. 5. Valid until secrecy maintained. National Intellectual Property Rights Policy 2016. 1. Vision. Creative India, Innovative India. 2. Strengthens IP ecosystem awareness and enforcement. 3. Promotes IPR education, training and innovation culture. 4. Fast-track IP filing in digital systems. 5. Creation of CIPAM cell for IPR promotion and management. 6. Balances public interest in innovation. Exam-ready revision points. Patent equals innovation. Trademark equals brand identity. Copyright equals creative rights. GI equals origin-based. Design equals aesthetic industrial product. Trade secret equals confidential business advantage. TRIPS equals global IP standards. Novartis case equals anti-evergreening. Section 3D Lesson 17. Law relating to trademarks. Regulatory Framework Sec. 1. 3. 1. Trademarks Act, 1999 replaced 1958 Act. 2. Trademarks Rules, 2017. Online filing introduced. 3. Aligned with TRIPS. 4. Madrid Protocol for International Registration 2013. 5. Administered by Registrar of Trademarks CGPDTM. 6. Main objective right pointing arrow protect brand identity and avoid consumer confusion. 7. TM offices. Delhi, Mumbai, Chennai, Kolkata, Ahmedabad. 8. Appeal lies to High Court IPAB abolished. Introduction Sec. 21 ZB. 1. Trademark equals mark capable of graphical representation and distinguishing goods services. 2. Forms. Word, logo, color, sound, shape, packaging, smell rare. 3. Helps brand recognition plus protection from misuse. 4. Business goodwill creation. 5. Statutory remedy equals infringement suit. 6. Common law remedy equals passing off. 7. TMBS registered only after registration. 8. Trademark can be used even without registration. Case law. Yahoo! Inc. vs. Akash Arora 1999. Court restrained Yahoo India website. Passing off protects unregistered marks 2. Procedure for registration 1. Search for availability public search portal. 2. File application right pointing arrow TMA form. 3. Examination by registrar. 4. Reply to objections if any. 5. Advertised in TM journal. 6. Opposition period 4 months. 7. Registration in TM certificate if no opposition. 8. Entry in register of trademarks. Processing in trademark registry. 1. Vienna classification for logos. 2. Allotment of application number. 3. Status stages. New right pointing arrow sent to Vienna. Right pointing arrow formalities checked. Right pointing arrow exam report. Right pointing arrow hearing. Right pointing arrow journal. Right pointing arrow registered. 4. Online status tracking. 5. Registrar may raise objections US 9 or 11. Absolute grounds for refusal Sec. 9. 1. No distinctiveness. 2. Descriptive marks. 3. Marks customary in trade. 4. Deceptive misleading. 5. Hurt religious sentiments. 6. Obscene scandalous. 7. Shape resulting from nature function of goods. 8. Generic words cannot be registered. Case. ITCV. Nestle 2016 Feet Magic Masala, not protected. Descriptive and laudatory term. Limitation as to color. 1. Color may be claimed specifically. 2. If not claimed right pointing arrow protection not limited to particular color. 3. Single color marks rare secondary meaning required. Relative grounds for refusal Sec. 11. 1. Similar to earlier registered pending mark. 2. Likelihood of confusion or deception. 3. Well-known marks protection even across classes. 4. International reputation also protected. Case. Coca-Cola vs. Bisleri 2009. Export of Mazza drink considered use in India. Global brand protection. Prohibition of names of chemical elements in Sec. 13. 1. Chemical element names cannot be trademarked. 2. INS WHO list prohibited e.g. paracetamol. 3. Purpose right pointing arrow prevent monopoly over generic medicines. Withdrawal of acceptance Sec. 19. 1. Registrar may withdraw acceptance of mark before registration. 2. Reason required. Hearing opportunity given. Advertisement Sec. 20. 1. Mark advertised in TM journal. 2. Purpose right pointing arrow invite public opposition. 3. Corrections can be requested. Registration Sec. 23. 1. Entry in register and certificate issued. 2. Date of filing equals date of registration. 3. Rights start from filing date. Duration, renewal, removal and restoration Sec. 25. 1. Valid for 10 years. Renewable every 10 years. 2. Grace period for renewal. 1 year. 3. Removal for non-renewal. 4. Restoration application. 1. 2 years from due date. Infringement of registered TM Sec. 29. 1. Identical similar mark right pointing arrow identical similar goods services. 2. Use likely to cause confusion. 3. Use in advertising domain names labels also infringement. 4. Famous marks protected even across classes. 5. Counterfeit goods seizure allowed. Case. Tata Sons vs. Manoj Dodia 2011. Unauthorized Tata on domain equals infringement. Penalties Sec. 103 to 105. Offense. Penalty. Counterfeit goods. 6 months. 3 years jail plus 50,000 rupees. 2 lakh rupees fine. False TM usage. Up to 3 years jail plus fine. Limits on effective TM Sec. 30. No infringement when 1. Honest concurrent use. 2. Descriptive use. 3. Comparative advertising without disparagement. 4. Parallel import genuine goods. 5. Use for educational descriptive reference. Passing off common law. 1. Protection for unregistered marks. 2. Must prove goodwill plus misrepresentation plus damage. Case. Cadbury vs. ITC 2017. Purple wrapper. Passing off if confusion created. Key difference. Statutory. Common law. Infringement. Passing off. Registered. Unregistered. Burden lower. Burden higher. Registration prima facie evidence Sec. 31. Certificate of registration equals prima facie proof of validity. Assignment and transmission Sec. 37. 45. 1. TM can be assigned with or without goodwill. 2. Must be in writing. 3. Recorded with registrar within 6 months extendable to 12 months. TM for company to be formed Sec. 46. 1. Proposed company may apply for TM. 2. On incorporation, rights vest in company. Removal for non-use Sec. 47. 1. Removal if not used for 5 years and 3 months from registration. 2. Genuine intention to use required. Registered user Sec. 49. 1. Licensing of trademark. 2. Must be recorded with registrar. 3. No assignment presumed. Registrar in TM registry. 1. Registrar appointed by central government. Sec. 3 to 5. 2. Head office Mumbai plus branch offices. Register of trademarks Sec. 6. 1. Contains details of marks, owners, assignments, users. 2. Public inspection allowed. Classification of goods services. Nice classification system followed 45 classes. Goods. Class 1 to 34. Services. Class 35 to 45 trademark agent rules. Making application. 1. Form TMG. 2. Qualifications. Graduation. Indian citizen. Clear TM agent exam. 3. Maintains dealings with TM registry on behalf of clients. Application for registration as a trademark agent. 1. Submit TMG plus fee. 2. Pass written exam plus Viva. 3. Name entered in register of TM agents. 4. Certificate issued. Important case law snapshot. Case. Principle. Yahoo vs Akash Arora. Passing off protects online marks. ITC vs Nestle. Descriptive terms cannot be TM. Coca-Cola vs Bisleri. International well-known mark. Tata vs Manoj Dodia. Domain infringement. Cadbury vs ITC. Packaging and trade dress protection. Quick revision table. Topic. Section. Definition. 21ZB. Absolute grounds. Sec. 9. Relative grounds. Sec. 11. In prohibition. Sec. 13. Advertisement. Sec. 20. Opposition. Sec. 21. Duration. Sec. 25. Infringement. Sec. 29. Penalties. Sec. 103 to 105. Non-use removal. Sec. 47. You're now ready for exam questions like: distinguish between infringement and passing off. Procedure of TM registration. Absolute versus relative grounds. Well-known trademarks protection lesson 18. Law relating to copyright. Regulatory framework 530. 1. Statute. Copyright Act, 1957 as amended in 2012. 2. Rules. Copyright Rules, 2013. 3. Admin Authority. Registrar of Copyrights. Copyright Board right pointing arrow merged with IPAB now functions under High Court. 4. International Conventions. Berne Convention. Universal Copyright Convention. TRIPS WTO. WIPO Copyright Treaty. 5. Jurisdiction. Civil and criminal courts have jurisdiction. 6. Digital protection. Copyright Amendment Act 2012 strengthened digital rights in DRM. 7. Objective. Encourages creativity by granting exclusive rights. Greater than case law. Eastern Book Company vs. DB. Mode Act 2008. Greater than headnotes and minimal creativity equals copyrightable. Mere labor sweat of brow not enough. Introduction 530. Copyright equals bundle of exclusive rights given to creator. Protects expression, not ideas. Applies to original literary, artistic, musical, dramatic works etc. Greater than case law. RG. Anand vs. Deluxe Films 1978. Greater than similar idea not infringement unless expression is copied. Works in which copyright subsists 532. 1. Literary works. Books, computer programs, tables, compilations. 2. Dramatic works. 3. Musical works. 4. Artistic works. Paintings, drawings, maps, architecture. 5. Cinematograph films. 6. Sound recordings. 7. Computer software. 8. Originality requirement. Skill plus judgment plus minimal creativity. Meaning of copyright 533. Rights include: 1. Reproduction. 2. Distribution. 3. Public communication. 4. Adaptation. 5. Translation. 6. Cinematographic and sound reproduction rights. Computer program rights also include commercial rental rights. Term of copyright 534. Work type. Duration. Literary, dramatic, artistic. Life of author plus 60 years. Anonymous pseudonymous. 60 years from publication. Cinematograph films. 60 years from publication. Sound recordings. 60 years from publication. Photographs. 60 years from publication. Government and public undertakings. 60 years from publication. Assignment of copyright 536. Copyright can be transferred plus licensed. Must be in writing with duration, territory and consideration. If duration not specified, right pointing arrow 5 years. If territory not specified, right pointing arrow India only. Greater than case. Indian Performing Rights Society vs. Aditya Pandey 2011. Greater than film producers have rights but composers retain underlying copyright unless assigned. Mode of assignment 537. Written agreement. Identifiable work. Royalty terms mandatory. Signed by a sign or agent. Disputes in assignment 537. Referred to Appellate Board High Court. Power to vary terms if unfair to author. Licenses 538. Types. 1. Voluntary licenses. 2. Compulsory licenses. 3. Statutory licenses. Compulsory license for withheld works 538. When work is withheld from public without justification. Granted by court board after hearing author. Compulsory license in unpublished works 539. For orphan works authors untraceable. Statutory license for broadcasting 539. Broadcasters can use literary, musical works by giving prior notice and paying royalty. Section 31D. Termination of license. If terms violated, right pointing arrow revocation. Copyright Society 540. Collective Management Bodies X, IPRS. Requires registration and government control. Broadcast reproduction right 541. 25 years from broadcast. Infringement includes recording or rebroadcasting without permission. Performers' rights 542. Performers, actors, musicians, dancers have special rights. Term. 50 years moral rights also included. Exclusive and moral rights of performer 542. Reproduction prohibited without consent. Moral rights. Integrity of performance. Copyright to foreign works 543. Reciprocity under Berne Convention, TRIPS. Registration 545. Not mandatory, right pointing arrow evidence in court. Diary, application, fee, public objection process. Infringement of copyright 548. Occurs when work copied, reproduced, communicated without authorization. Substantial similarity required. Greater than case. Star India vs. Leo Burnett. Greater than test equals whether ordinary viewer identifies copying. Statutory exceptions fair use 549. Section 52. Not infringement when used for private personal use, research, education, review or criticism, reporting current events, judicial proceedings, making 3 backup copies of software. Libraries preservation. Greater than case. Supercassettes vs. Hamar Television 2010. Greater than fair use interpreted liberally for news channels. Remedies against infringement 553. Civil. Injunction. Damages accounts of profit. Delivery of infringing copies. Anton Pillar order search and seize. Criminal. Imprisonment 6 months. 3 years. Fine 50,000 rupees. 200,000 rupees first offense. Enhanced for subsequent offenses. Protection of rights management info 554. Punishment for removing or altering DRM information. Offenses and penalties 554. Offense. Penalty. Infringement. 6 months. 3 years plus 50,000 rupees. 2 rupees L fine. Second offense. 1. 3 years plus rupee 1 L. 2 rupees L fine. Using false entries. Up to 1 year imprisonment. Police power to seize. Police may seize without warrant. Sec. 64 must produce accused before magistrate. Important quick exam notes. Copyright protects expression not idea. Originality equals skill plus labor plus judgment plus minimal creativity. Software is literary work. Movie soundtracks right pointing arrow dual copyright. Fair use under section 52. Term equals life plus 60 years. Criminal penalties exist right pointing arrow unique to copyright. High yield case laws to mention. Case. Point. RG. Anand vs. Deluxe Films. Idea versus expression. EBCV. Modak. Modicum of creativity test. Supercassettes vs. Hamar TV. Fair use defense. IPRSV. Aditya Pandey. Composer rights. Star India vs. Leo Burnett. Substantial similarity test. Lesson 19. Law relating to geographical indications of goods. Regulatory Framework 560. 1. Statute. Geographical Indications of Goods Registration and Protection Act, 1999. 2. Rules. GI Rules, 2002. 3. Admin Authority. Geographical Indications Registration I. 4. Supervision. Controller General of Patents, Designs and Trademarks. 5. International Treaties. TRIPS WTO. Arts 22, 24. Paris Convention. 6. Objective. Protect products uniquely linked to region. 7. Covers. Agricultural, natural and manufactured goods. Greater than case law. T Board of India vs. ITC Limited. 2011. Greater than Darjeeling GI protection upheld. Cannot be used as business name without authorization. Introduction 560. GI equals name mark identifying goods originating from a region where quality, reputation, characteristics linked to geography. Example. Darjeeling tea, basmati rice, Kanchipuram silk. A community right, not individual right. Geographical indication 560. Key points. 1. Indicates origin of goods. 2. Link between place plus quality reputation. 3. Protects rural artisans and farmers. 4. Prevents misuse and unfair trade. 5. Cannot be licensed like a trademark to outsiders freely. Indication 561. Words, symbols, labels showing products' geographical origin. Must not mislead public regarding area of origin. Prohibition of registration of certain GIs 561. Registration denied if 1. Likely to deceive public. 2. Contrary to law. 3. Hurt religious sentiments. 4. Generic names e.g. cheddar. Originally GI but now generic. 5. False indication not originating in territory. Registration of GI 562. Compulsory for legal protection. Provides exclusive right and protection against misuse. Application for registration 562. Filed by 1. Association of persons. 2. Producers. 3. Government body. Requirements. Statement of case. Proof of origin. Map of territory class of goods. Inspection structure. Government verifies and publishes in GI Journal. Registration process. Step-by-step 563. Step. Description. 1. File application with forms plus fee. 2. Preliminary scrutiny by registrar. 3. Show cause notice if objections. 4. Hearing before registrar. 5. Publication in GI Journal. 6. Opposition 3 months plus 1 month extension. 7. Registration and issuance of certificate. Duration of registration 565. Valid, 10 years. Renewable indefinitely every 10 years. Can be removed for non-renewal. Infringement of unregistered GI 566. Passing off action available, similar to trademark passing off. Greater than case law. Basmati Rice case Apeta v. Rice Tech Inc. USA. Greater than India stopped US firm from calling rice basmati proving GI reputation. Infringement of registered GI 566. Occurs when 1. GI used by unauthorized persons. 2. Misleading consumers on origin. 3. Creates unfair competition. 4. Dilutes quality or reputation. Remedies. Civil and criminal actions. Injunctions. Damages. Seizure and destruction of goods. Assignment transmission 566. GI cannot be assigned, transmitted, licensed or mortgaged. Reason. Community right. Tied to region. However, registered users can be allowed usage. Prohibition of GI is trademark 567. TM registration refused if it consists of a GI for goods not originating there. Prevents consumer deception. Offenses and penalties 568. Offense. Penalty. Applying false GI. 6 months. 3 years plus 50,000 rupees. 200,000 rupees. Selling goods with false GI. Same as above. Enhanced punishment. For repeat offenses. Court can seize goods. Order destruction of labels, packaging. Award damages. Meaning of applying GI 568. Includes physical labeling on goods, packaging advertising, using device mark on documents signifying GI, falsifying and falsely applying GI 568, making imitation GI, material alteration, selling goods as GI products without authorization. Penalty for applying false GI. Imprisonment. 6 months. 3 years. Fine. 50,000 rupees. 2 lakh rupees. Second or subsequent offense right pointing arrow higher punishment. Court may reduce punishment for special and adequate reasons. Key exam case laws. Case. Principle. T-Board vs. ITC Darjeeling. GI word use restricted. Apeta v. Rice Tech Basmati. Protection against foreign misuse. Champagne case EU. GI stops generic use misuse globally. Kashmir Pashmina case. Certification for authenticity required. Important Indian GIs high scoring in CS exam. State. GI product. West Bengal. Rasgulla. Uttarakhand. Basmati rice. Karnataka. Mysore silk. Kerala. Alleppey green cardamom, Aranmula mirror. Tamil Nadu. Kanchipuram silk. Kashmir. Pashmina shawl, saffron. Assam. Muga silk. Goa. Feni. Exam focused quick notes. GI equals community right. Protects geographical quality and authenticity. Term equals 10 years, renewable indefinitely. GI cannot be assigned license like TM. Action available even for unregistered GI. Passing off. GI misuse equals criminal offense. Enforcement crucial under TRIPS. Memory tricks. Concept. Trick. GI equals place identity. GI equals geography identity. Cannot be assigned. GI stays with the soil. Duration. 10 years, again and again. Lesson 20. Law relating to designs. Regulatory Framework 572. 1. Primary Law. Designs Act, 2000. 2. Rules. Designs Rules, 2001. 3. Admin Body. Patent Office under CGPDTM. 4. Objective. Protect aesthetic visual design of articles. 5. Covers. Features of shape, configuration, pattern, ornamentation. 6. International Convention. Paris Convention, TRIPS. 7. Designs Database. Design Register maintained by Patent Office. 8. Purpose. Prevent piracy, encourage creative industry. Exam tip. Designs protect appearance, not function. Functional innovations equals patents. Introduction 572. Protects aesthetic look of industrial products. Encourages industrial innovation and market value. Protection to original artistic ideas applied on articles. Prevents cheap imitation and counterfeits. Design 573. Meaning and essentials. Legal definition under Section 2D. 1. Features of shape, configuration, pattern, ornamentation. 2. Applied to article by industrial process. 3. Judged solely by eye appeal. 4. Must be new or original. 5. Not disclosed publicly prior to filing. 6. Cannot include trademark mechanical device functional features. 7. Includes 2D and 3D designs. 8. Mass production required. Scope example. Bottle-shaped Coca-Cola, container patterns, upholstery design. What designs do not cover? Functional mechanical features. Mode of construction. Artistic works under Copyright Act. Trademarks logos. Computer programs. Proprietor of a new or original design 576. Who can apply? 1. Author of design. 2. Employer of designer. 3. Person who commissions design. 4. Legal successor assignee. Prohibition of registration of certain designs 576. Design cannot be registered if 1. Not new original. 2. Previously published or known. 3. Not significantly distinguishable. 4. Contains scandalous matter. 5. Functional features only. 6. Contrary to public order or morality. 7. Trademark property mark included. Leading case law. Bharat Glass Tube Limited vs. Gopal Glass Works Limited. 2008. Supreme Court held a new pattern on glass sheet eligible as design. Originality confirmed. Application for registration section 5577. 1. Filed in Patent Office in prescribed form. 2. Mention class of article Locarno classification. 3. Representations drawings photos required. 4. Statement of novelty must be mentioned. 5. Examination for originality and novelty. 6. Foreign priority claim allowed within 6 months. Registration in respect of particular article Sec 6578. Design is granted per article category. If same design used on multiple articles, right pointing arrow separate applications. Publication of particulars 579. After registration, design details published in Design Journal. Public inspection allowed. Certificate of registration 579. Issued by controller. Proof of ownership. Admissible in Court Register of Designs 580. Contains names, addresses, design number and class, date of filing, renewal details, assignment history, copyright ownership on registration 580. Term, 10 years. Extendable 5 more years. Right pointing arrow total equals 15 years. Rights. Exclusive right to apply design. Right to sue infringers. Right to license and assign. Memo term trick. 10+5 rule. Restoration of lapsed designs 581. 1. If renewal fee not paid, right pointing arrow lapses. 2. Restoration application within 1 year. 3. Controller may restore if failure was unintentional. Designs binding government 582. Government also bound by act. Government must respect design rights. Can use design only with authorization. Industrial and international exhibitions 582. Temporary exposure in exhibition does not destroy novelty. Condition. Must file for protection within 6 months. Appeals. Appealable to High Court. Appeal against controller decisions. Infringement piracy of design. Occurs when 1. Unauthorized copy mimic design. 2. Sell import article using registered design. Penalties. Offense. Penalty. Design piracy. 25,000 rupees fine per contravention. Maximum total damages. Up to 50,000 rupees per design. Civil suit. Injunction plus damages plus seizure. Memo court may order delivery up of infringing goods. Memo memory hacks. Topic. Mnemonic. Design protects appearance. I appeal equals design deal. Term. 10+5 equals 15 heaven. Can't cover function. Function. Go patent junction. Practical examples. Product. Protected feature. Coca-Cola bottle. Shape. Tupperware containers. Shape ornamentation. Jewelry models. Pattern. Fabric prints. Ornamentation. Exam quick points. Section 2D equals definition of design. Class under Locarno classification. New and original essential. Published design cannot be registered. Term equals 10 years plus 5 years extension. Piracy penalty equals 25,000 rupees per act. Memo case laws must remember. Case. Principle. Bharat Glass Tube Limited vs. Gopal Glass Works. Novel design protected. Microfibers Inc. vs. Girdhar and Company. Design vs. Copyright boundary. Dabur vs. Rajesh Kumar. Container shape is design.